Butterfly effect in investment arbitrations. How foreign investors may sue Spain because of Russia and Norway. This analysis traces possible ramifications of third states' actions in the context of investment arbitration. A third state's action may have a butterfly effect, prompting foreign investors to initiate investment arbitrations against their respective host states. Although to a certain degree this is not a new phenomenon, multiple investment arbitrations had been triggered by the EU Commission urging the repeal of various state aids. It is certainly a rarer occurrence outside of an international organization. The critical actions will be discussed here are Russia's characterization of a species as sedentary and Norway's conflicting interpretation of a multilateral treaty. Such actions may have triggered a chain reaction of events bearing legal implications for Spain. The EU snow crabs fleet. Since 2012, EU trawlers have begun harvesting snow crabs, a relatively new species in Europe's waters. This novel activity is a highly profitable business. Reportedly, each snow crab trawler yields €1 million per month on average, and arguably environmentally friendly. Indeed, snow crabs are infesting Europe's waters since they are an alien species migrating from the Russian coast where they were artificially introduced in the 1960s. Being a non-indigenous species prone to overbreeding, if they are not regularly caught, they harm the ecosystem. The EU Commission has been authorizing a few member states, specifically Spain, Estonia, Lithuania, Latvia, and Poland, to issue permit to catch snow crabs. The trawler flying the Spanish flag, the Adexe Primero, actually pioneered the catch of snow crabs in Europe since 2012. The Spanish vessel focused her activities on the loophole area, a small portion of international waters between Norway and Russia in the Barents Sea, and in the waters surrounding the Svalbard archipelago. This vessel carried out her activities on the ground of the fishing permits issued by Spain, specifically a NEA-FC zone permit for the loophole area and a Svalbard zone permit for the Svalbard waters. Vessels of the contracting parties to Northeast Atlantic Fisheries Commission, or NEA-FC, can indeed get a permit from their flag state to freely catch unregulated stocks, such as snow crabs, in international waters, like in the loophole area. Similarly, vessels of the signatories to the 1920 Treaty of Paris can get a permit from their respective flag states to fish around Svalbard on the same footing as Norwegians. Both Adexe Primero's fishing grounds proved to be so profitable that other EU and Norwegian vessels followed her routes. Crimea sanctions and Russia's take on snow crabs. Following EU sanctions on Russia for the 2014 Crimea annexation, Russia, in retaliation, began obstructing EU vessels fishing in the Barents Sea. For instance, on the 16th of July 2015, the Adexe Primero herself was arrested by a Russian patrol boat while fishing in international waters in the Barents Sea. The arrest was prompted by the detection of fishing pots with foreign signs in Russia's exclusive economic zone, or EEZ. The pots belonged to the Adexe Primero and to a Norwegian vessel, the Northeastern H-27AV. It turned out that the pots had been drifted by the current of the sea into Russia's EEZ. The Spanish vessel was then released after posting a bail. On the 27th of July 2015, Russia's retaliations built up to a declaration defining the snow crabs, usually fished by EU vessels in the international waters of the loophole, as a sedentary species living on the continental shelf. As such, the exploitation of this valuable resource should be up to the coastal states, Russia and Norway, who also joined this declaration, being in her best interest at the time. The international waters of the loophole in the Barents Sea arise because Russia's and Norway's EEZ cannot extend further out to sea than 200 nautical miles. The loophole is squeezed between the two EEZs. However, the continental shelf can extend up to 350 nautical miles, thus engulfing the seabed underneath the loophole. Therefore, the continental shelf below the water column in the loophole can be subject to Russia's and Norway's jurisdiction, despite the water column above lies in international waters. By defining the snow crab as a resource of the continental shelf, instead of a high seas fishery resource, the coastal states, Russia and Norway, gain jurisdiction over this precious resource and accordingly the right to exploit it exclusively and simultaneously erode one of the freedoms of the high seas, the freedom of fishing. Interestingly, the characterization of crabs as sedentary species is not univocal and is rather arbitrary, often driven by national economic interests. Japan, a traditionally distant water fishing country, considers crabs as a high seas fishery resource. Arguably, crabs' ability to migrate defies their sedentary feature. Other states, mostly coastal states such as Canada, hold that this crustacean is a sedentary species. It remains doubtful whether crabs, as other crustaceans, are sedentary or high-seas species. For example, Brazil considers lobsters sedentary, whereas the UK deems they are not. Following Russia and Norway's joint declaration, in August 2015, the EU recommended to its member states to suspend the permit to catch snow crabs in the loophole. Accordingly, Spain suspended Adexe Primero's permit to fish in the NEAFC zone. Other EU member states instead disregarded the EU's recommendation and let their trawlers keep fishing in the loophole. Finally, in September 2015, Spain followed the example of the other member states and lifted the suspension of Adexe Primero's permit for the NEAFC zone. Afterwards, Spain renewed Adexe Primero's permit for the 2016. However, in March 2016, Spain suspended the permit for the NEAFC zone once again and eventually stopped issuing it altogether, apparently out of deference to Russia's stance. Norway's international breaches. The 1920 Treaty of Paris governs the international status of the archipelago of Svalbard. Just a year earlier, in 1919, the geographer and explorer Robert Neil Rudmose Brown describes the archipelago as a no-man's land whose natural resources have been explored and exploited by a variety of states since its discovery. Indeed, in June 1914, all nations that had a competing claim to Svalbard came to terms with the fact that the archipelago was terra nullius. In the aftermath of the First World War, the twofold need for some sort of local authority administering the international community living on the archipelago and for avoiding its militarization called for the negotiations of the Treaty of Paris. The contracting parties to this treaty agreed to give Norway sovereignty over Svalbard to perpetuate the joint and peaceful exploitation of the archipelago's natural resources by a variety of nations. The treaty accords to each contracting state's nationals the right of economic activity on an entirely equal footing with Norwegian nationals, thus preserving the terra nullius status. This instrument formalizes the acquired rights of the international community. By virtue of this treaty, Svalbard is indeed the only land state territory of common use in modern international law. However, over time, Norway has discriminatorily restricted the commercial access of the other signatory citizens based on nationality requirements. While Norway has disavowed the Treaty of Paris by depriving its provisions of their original meaning, constraining Norway's sovereignty over the archipelago in favor of the international community's acquired rights, Norway has also relied on the same treaty to extend an unrestrained sovereignty on the waters surrounding Svalbard up to 200 nautical miles and, accordingly, to expand its maritime boundaries bordering with Greenland. Thus, Norway inconsistently interprets the geographical scope of the treaty. On one hand, Norway holds that the Treaty of Paris applies only up to 12 nautical miles off the archipelago. On the other hand, Norway stretches her maritime boundaries with Greenland up to 200 nautical miles off Svalbard thanks to the same treaty which conferred sovereignty upon Norway over Svalbard, but which is limited, according to Norway, up to 12 nautical miles around the archipelago. Russia and the EU object Norway's interpretation of the treaty, as every other contracting party, since if it wasn't for the Treaty of Paris, Norway could not set her border at 200 nautical miles off Svalbard. Hence, either the Treaty of Paris applies up to 200 nautical miles off Svalbard and Norway retains her current maritime border with Greenland, or the treaty applies up to 12 nautical miles and Norway's maritime borders as well as territorial jurisdiction are to be downsized accordingly. Should the territorial scope of application of the treaty be up to 12 nautical miles off Svalbard's baseline, the portion of water between its outer edge and Greenland's EEZ would be considered high seas. Should Svalbard's continental shelf stretch further than 12 nautical miles into the high seas, the Treaty of Paris would apply to that zone anyway, since the continental shelf is a prolongation of Svalbard's land territory. Therefore, regardless of the geographical scope of the Treaty of Paris, either up to 12 or 200 nautical miles, this instrument should apply to the activity of snow crabs catching around Svalbard, because such activities occur on its continental shelf. Norway indeed considered snow crabs as a resource of the continental shelf in her 2015 joint declaration with Russia. Accordingly, the nationals of all contracting parties of the Treaty of Paris should be allowed to catch snow crabs on Svalbard's continental shelf just as Norwegians do. Norway's 2015 joint declaration with Russia concerning the sedentary nature of snow crabs might have seemed beneficial at the time to gain jurisdiction over this natural resource on the continental shelf underneath the loophole. However, the same declaration might backfire Norway's interests in Svalbard. Indeed, such declaration indirectly obliges Norway to accord equal commercial rights to foreign snow crabs trawlers on Svalbard's continental shelf, which, being a prolongation of Svalbard's land territory, is covered by the application of the Treaty of Paris. In other words, EU trawlers can harness snow crabs on Svalbard's continental shelf for the same reason they cannot catch them in the loophole area. Since June 2013, Adexe Primero began fishing in Svalbard waters thanks to a permit granted by Spain based on the Treaty of Paris. However, following Norway's arrest of a couple of EU trawlers in January 2017, Spain suspended indefinitely such permit, despite the EU recommend it to disregard Norway's prohibition to catch snow crabs around Svalbard. Spain was indeed the only EU member state to adopt such suspension, unlike Estonia, Lithuania, Latvia, and Poland. Norway's discriminatory actions have already led to investment arbitrations concerning the catching of snow crabs in Svalbard waters. Could Norway's flawed interpretation of the Treaty of Paris result into similar repercussions for other states?
Investment arbitrations drifting towards Spain?
Russia's erosion of the freedom of fishing in the high seas by defining snow crabs as a resource of the continental shelf, and Norway's violation of the Treaty of Paris may have led Spain to breach in turn her international obligations towards her foreign investors. The EU member states who were granted snow crabs catching permits by the EU reacted in different ways to Russia and Norway. On one hand, Estonia, Lithuania, Latvia, and Poland stood firm on their position and kept on allowing their vessels to catch snow crabs in the loophole and around Svalbard. On the other hand, Spain had repeatedly suspended Adexe Primero's permits and, eventually, stopped issuing them altogether out of fear of Russia and Norway.
Spain's repeated suspensions of the snow crab catching permits and their ultimate revocation have disrupted the activity of the Adexe Primero and her shipowner Mariscos Polar S.L., a company registered in Spain with the purpose of fishing crabs in Arctic waters and whose shareholders hold Russian and Moldavian nationalities. These Russian and Moldavian investors may invoke respectively the Spain-Russia Bilateral Investment Treaty and the Spain-Moldova Bilateral Investment Treaty to put forward an expropriation claim against Spain. Indeed, Spain directly expropriated the snow crab catching permits and indirectly expropriated the foreign investors' company operating thanks to those permits.
The cumulative effects of the continual suspensions of the permits, culminated with their revocation, may well amount to a creeping expropriation. Spain's consequential expropriation of Mariscos Polar is worsened by the fact that the actions leading to this taking were not proportional. Firstly, there was a lack of proportionality since Spain did not provide for alternative fishing grounds to avoid the total disruption of Mariscos Polar's business.
Secondly, the absence of proportionality is given by the fact that Spain was the only EU member state in adopting such a harsh measure.
Hence, even if Spain's drastic actions may have been taken because of Russia and Norway, their lack of proportionality and compensation do not exempt Spain from her international obligations towards her foreign investors.
Importantly, Article 6 of the Spain-Russia BIT, as well as Article 5 of the Spain-Moldova BIT, cover not only direct expropriations, but also any other measures with similar effects. Hence, the applicable BITs allow for indirect and creeping expropriation claims.
Being fishery part of the EU common policy, the treatment Spain accorded to Mariscos Polar should be contrasted with the treatment that other EU member states in the same position as Spain accorded to enterprises operating in the same sector as Mariscos Polar. If such treatment is more favorable than the one accorded by Spain, then Spain failed to accord Mariscos Polar the most favorable treatment she could have possibly accorded.
Since the other EU member states did not suspend their snow crabs permits, Spain may be in breach of the Most Favored Nation Clause and Article 5.2 of the Spain-Russia BIT and Article 4 of the Spain-Moldova BIT. Further, the Russian investor may rely on the MFN clause also to broaden the scope of the Dispute Resolution Clause. This way, the Russian investor may bring in a fair and equitable treatment claim,
or FET claim,
and a full protection and security claim. Whereas the Moldovan investor would not need to invoke the MFN clause for such purpose, since the dispute resolution provision of the Spain-Moldova BIT is not limited to expropriation claims.
Spain breached the FET standard
towards her foreign investors insofar as it failed to protect their legitimate expectations with respect to their investment by generating an unstable legal framework for catching snow crabs. Notably, the investors' legitimate expectations were also backed up by the EU's recommendation to ignore Norway's prohibition of fishing in Svalbard.
Moreover, Spain failed to accord an adequate legal protection against Norway's subsequent claims to the fishing rights that Spain granted to her investors in the first place. Spain could have protected such rights by resorting to an international arbitration against Norway based on the 1929 Spain-Norway Treaty on Conciliation, Judicial Settlement, and Arbitration. Not only did Spain fail to accord an appropriate legal protection to her foreign investors to ensure the normal ability of their business to function, but she also deprived the investors of the title, the fishing permit, to advance a possible investment claim against Norway by invoking the Russia and Norway bit.
Accordingly, the foreign investors may claim from Spain compensation for the damages suffered,
the restitutio in integrama of the revoked permits, and their adequate legal protection through an international legal proceeding between Spain and Norway. Bottega di Bella, empowering your international rights.